Hey folks, Timbo here. Brooke and I wanted to come on together, but she's having some technical difficulties. But I wanted to break down the enormous boom that we've all been waiting for, and that's the lawsuit that the state of Texas has filed against the Commonwealth of Pennsylvania and the states of Georgia, Michigan, and Wisconsin. Let me explain why this is important, because this wraps up all of the causes of action into one suit. You'll remember we've got state case in Pennsylvania that is being appealed to the Supreme Court. We have direct federal cases in Michigan and in Georgia and in Wisconsin, but those are all wending their way through. This case will be heard immediately. It was filed before the end of the safe harbor. And for those that don't understand, today is the safe harbor day for states to certify elections. After today, any challenge to the election is going to be deemed to be too late. So this is the state harbor for the states that if they certify by today, they can guarantee that once they get past today, they don't have to worry about any lawsuits. They can go ahead on the 14th and have their electors meet to vote for who they want to be president, whether it's going to be the Trump electors or the Biden electors. Because remember, as is stated in this complaint and in this brief that I'm going to break down for you, I've been telling you for months, there is no constitutional right to vote for president or vice president. The only reason we have elections is that it's a creation of state law. In fact, in the first election, we didn't have all the states submitting slates of electors. In the second election, 10 of the 15, the legislatures picked them themselves. Until 1860, we still had states that were just having the legislatures choose the electors, and that's how the states would choose their electors. Elections are creations of state law. So once the state law allows an election or creates an election, then you do have constitutional rights and you've got statutory rights under the various, the Voting Rights Act in 1964 being the latest. However, the state legislatures have the plenary power to choose the electors. It can neither be abrogated nor abdicated. The legislature has this sole power. They can take it back under the McPherson case of 1894. They can take back that power from the executive branch at any time. They cannot have the executive or the courts take it away from them. That's what I mean about it. It cannot be abrogated by the state executive or the state judiciary, and it can't be abdicated by the legislature. The legislature, even if it delegates to the executive the right to hold an election and sets the rules for holding an election, it can always take that right back. It's a plenary power. They can always take that power to choose electors back. And that's what had been asked for, because the executive didn't follow the rules. Well, what we have now is a little bit different situation, because, for example, in Pennsylvania, it's Sean Parnell and another plaintiff that were candidates for election, and they had standing because they were candidates and they were alleging that the election didn't follow the rules. Well, that case isn't as strong as this case. Why? Because this is one case, or one state, Texas, saying to the Supreme Court, the fact that the Commonwealth of Pennsylvania and the states of Georgia, Michigan, and Wisconsin didn't follow their statutory schema for setting election, didn't follow the rules that they set for themselves, that violates our citizens' rights, because our citizens played by the rules that we, the state of Texas, established. We, the state of Texas, are relying on the Commonwealth of Pennsylvania, the states of Georgia, Michigan, and Wisconsin to make sure that their elections followed the rules that they set. They didn't do that. Therefore, if we voted for Donald Trump, our electors are going to be voting for Donald Trump. In the fact that the elections in Georgia, Pennsylvania, Michigan, and Wisconsin didn't follow the rules, and I'll get into how they didn't follow the rules in a minute. That disenfranchises our citizens. It weakens our votes because Biden is going to get electors from those states, and those states didn't follow the rules, so Biden shouldn't get those electors. Okay, that's this case in a nutshell. Now, digging down deeper, if you looked at the pleadings, there were 3 pleadings on the scribed link I sent. There is a motion for leave to file a bill of complaint. There's the brief in support of the motion to file the bill of complaint, and then there's the bill of complaint. So what does that all mean? In order to get a court to do something, you have to file a motion. You have to move the court. Plaintiff moves that the court do X, Y, and Z. This is what we're asking for, and this is why we're entitled to it. Then that's very short. And then you have the brief, the legal brief that supports that motion. So the first thing that's going to happen is there's going to be a motion for leave to file. The defendant states are going to oppose that motion. However, all the plaintiff has to show to survive the motion for leave to file the complaint is that there is a justiciable case. Prima facie case, first face is what it literally means. Common way of saying it is at first blush. If you just look at it at first blush, yes, there's a case. And the state of Texas alleges that, as set forth in the accompanying brief and complaint, the 2020 election suffered from significant and unconstitutional irregularities in the defendant states. Non-legislative actors, meaning the state judiciary and the state executive, the governor and the secretary of state, purported amendments to states' duly enacted election laws in violation of the Electors Clause vesting state legislatures with plenary authority regarding the appointment of presidential electors. What that means is the state executive and the state judiciary modified the rules that we, the legislature, set, and that's improper. Secondly, intrastate differences, meaning differences within the states in the treatment of voters, with more favorable treatment allotted to voters, whether lawful or unlawful voters, in areas administered by local government under Democrat control and with populations with higher ratios of Democrat voters than other areas of defendant states, meaning Gwinnett County and Fulton County and Cobb County treated their Democrat citizens differently than they treated citizens in more Republican counties. Now, you might ask, why does Texas care that states treat residents of one of their counties differently than of other of their counties? That's a Georgia matter, for example. Well, the reason is that under Bush v. Gore 2, the second Bush v. Gore in 2000, it's a violation of the Equal Protection Clause for the state to treat residents in one county differently than it treats states in the other county. The state has violated those citizens' rights under the Equal Protection Clause. And because it's a constitutional violation, not a state law violation, it's a constitutional violation, that impairs, that affects our Texas voters. Because Georgia violated its citizens' constitutional rights, that created an outcome which violates our Texas citizens' constitutional rights. And then finally, the appearance of voting irregularities in the defendant states that would be consistent with the unconstitutional relaxation of ballot integrity protections in those states' election laws, meaning that because they violated the state's election laws, that produced a result which cannot be relied on. And because it produced a result that can't be relied on, that is going to impair our Texas voters' rights under the Constitution. All these flaws, even the violations of state election law, violate one or more of the federal requirements for election, that is the equal protection, due process, and the Electors Clause, and thus arise under federal law, meaning it's a federal case, even though we're alleging violations of state law. And again, that's citing Bush v. Gore in 2000, quoting, significant departure from the legislative scheme for appointing presidential electors presents a federal constitutional question. Now, when you're reading a brief and you see all these case citations, you're going to want to read the part that's quoted, because what you do in a brief, you make a statement and then you cite case law in support of that statement. And in the citation, it should contain a specific reference to the language in that case that you're citing that directly supports your statement. So every statement you make in a brief needs to be supported by case law. Plaintiff state, Texas, respectfully submits that the foregoing types of electoral regularities exceed the hanging Chad saga of the 2000 election in their degree of departure from both state and federal law. Moreover, these flaws cumulatively preclude knowing who legitimately won the 2020 election and threaten to cloud all future elections. Taken together, these flaws affect an outcome determinative number of popular votes, meaning the number of votes affected is going to determine the outcome, in a group of states that cast outcome determinative numbers of electoral votes, meaning the electoral votes of Georgia, Pennsylvania, Michigan, and Wisconsin will change the result of the election. So this is significant. This isn't, we're not arguing about something that doesn't matter. This matters. This court should grant leave to file the complaint and ultimately enjoin the use of unlawful election results without review and ratification by the defendant states' legislatures, and remand to the defendant states' respective legislatures to appoint presidential electors in a manner consistent with the Electors Clause and pursuant to 3 U.S. Code Section 2. Now, what that's saying is, don't just throw this back to the states. Order the state legislatures to select the electors in their states. So that's the motion. And then the brief is in support of that motion. And there's some great language there. But before we get there, I want to point to the complaint. Because what the complaint is, it's the actual lawsuit. It's the cause of action. And what it is saying in the introductory portion is that the only date that's mandated under the Constitution is the January 20 inaugural date. So today's safe harbor date, the 14th date, they are creations of law and they can be overridden by the court. It's also saying that this is the only court. See, when you go into court, first you have to prove that the court has jurisdiction. The court is competent to hear this case. Then you have to prove venue, that it's the right court. So there's no other court that would be better suited to hearing this case. So it's, the first analysis is, yes, you have the power to hear this case. That's the jurisdiction analysis. The venue analysis is there's no other court that would be better suited to hear this case. And then the third analysis is standing. Does the plaintiff have standing to sue? And as I've just said, because it involves a federal question and because it involves constitutional issues, and it's because it's the state suing the Commonwealth of Pennsylvania and the states of Georgia, Michigan, and Wisconsin, the state of Texas does have standing. One of the things you want to do in your pleadings is, because what's going to happen here, the first thing that there's going to be, there might not even be a hearing. They might just make a decision. The Supreme Court might just make a decision on the pleadings, which is what I expect. So they get the plaintiff's motion for leave to file the bill of complaint. They get the plaintiff's brief in support of that motion, and then they'll get the defendant's various briefs in opposition to the motion. And they might just go on those pleadings. And I wouldn't expect them to have a hearing just for granting leave to file the bill of complaint. If they grant the motion, that means Texas is able to file the bill of complaint. And then we're going to have additional pleadings and probably oral argument as well. But I'm not expecting oral argument just for the motion. Now, in the complaint itself, one of the things you want to do in the pleadings is not only set forth your arguments as to why the court should do what you're asking it to do, but you've got to strategize and put yourself in the defendant's shoes and try to anticipate the arguments that they will make and blunt them. You want to rebut their strategy. You want to rebut their arguments before they even make them. And Texas did that in the complaint. On page 6, paragraph 8, one of the things that has already been alleged, was alleged in Pennsylvania, is the doctrine of latches. And we discussed this in the last video. It's L-A-C-H-E-S, not L-A-T-C-H-E-S. It's not a door latch. It's latches, L-A-C-H-E-S. And what that means is that you waited too long to file your lawsuit. The flip side of that coin is ripeness. You cannot file a lawsuit before the case is ripe for adjudication. So it has to be ripe, but you can't wait until it's rotten. Okay, that's ripeness in latches. Ripeness means you can't sue before you've got a cause of action. Latches means you waited too long, and after you had a cause of action, your delay was it would be unfair to go back and sue now because you delayed. You waited too long, and that delay would be unfair to the defendant. Well, what Pennsylvania is arguing is that the case is barred by latches, and they got a federal judge to sign off on this, which blows me away, because a trial judge, the last thing a trial judge wants is to be overturned on appeal. Why? Not only because it's embarrassing, but what does a trial judge want? Trial judge wants to be named to an appellate court. You're not going to be named to an appellate court if you're a judge that's gotten overturned a lot on appeal, because it clearly shows that you're not going by the law. You're going according to personal opinions, popular sentiment, whatever, but not the law. Because again, when you get to the appellate level, that is when you're not arguing the facts anymore, you're just arguing the law. So you don't want to be overturned on appeal if you're a trial court judge. Well, trial court judge in Pennsylvania, who we think is pretty corrupt, and in the pocket of the Democrats, if not the Chinese, you have to investigate that a little further, ordered that dismiss the lawsuit based on the doctrine of latches, saying that the plaintiffs waited too long. It's like, but wait a second, hold your horses. Just because we waited a year after the Secretary of State made the new rules, there wasn't an election until now. The case wasn't ripe before the election. We had no cause of action. If we had sued before the election, it would have been dismissed because there hadn't been an election. There was no cause of action. Anytime your allegation is dependent on contingencies, which may or may not occur, the case isn't ripe. You have to wait until it does or doesn't occur. Those contingencies do or don't occur. So that is where we stand with regard to latches and ripeness. So because Pennsylvania already tipped their hand on the latches issue, Texas, and I'm telling you, they started drafting this the day after the election. And understandably, the cases filed by Sidney Powell and Lynn Wood in Georgia and Michigan were put together very quickly. They did a great job given the time constraints, but they weren't as thorough and as complete as, for example, the case that was refiled last Friday. The case that was refiled in Georgia on Friday was very well done, laid everything out, bing, 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 bing. It was clearly not rushed. The other cases, kind of rushed. But again, excusable given the time constraints. This case, this complaint, this motion, this brief in support of the motion are works of art. I was laughing all the way through them. They are brilliant. Every single statement supported by case law, not just the same cases either. A whole bunch of different cases. A whole lot of legal research went into this, and there's no way that the defendants can argue against these citations because these citations are the controlling law. Moreover, Texas got out ahead of Pennsylvania on this. Paragraph 8 of the complaint on page 6, nor was this court immune from the blatant disregard for the rule of law. Pennsylvania itself played fast and loose with its promise to this court. SCOTUS, don't believe anything Pennsylvania tells you. They've already lied to you just 2 weeks ago. In a classic bait and switch, Pennsylvania used guidance from its Secretary of State to argue that this court should not expedite review because the state would segregate potentially unlawful ballots. We promise on our honor that we will segregate potentially unlawful ballots. So if they don't have a signature or there's no address, we promise to segregate them. And Justice Alito said, okay, but I'm ordering you, Pennsylvania. I'm ordering you, Secretary of State. You segregate those ballots. We all know what happened. A court of law would reasonably rely on such a representation. Why would you not believe an elected Secretary of State that's before the Supreme Court? Why would you not believe him? You'd give judicial deference to that executive officer. Remarkably, but not surprisingly, before the ink was dry on the court's 4-4 decision, Pennsylvania changed that guidance, breaking the state's promise to this court. Boom! Which gets us also back to why Justice Gorsuch's concurring opinion in Archdiocese of Brooklyn against Cuomo was wonderful, because John Roberts said, I dissent in part because there was a remedy, and the state changed the rules and they can have church now. And Gorsuch said, are you kidding me? As soon as the decision comes down, they're going to change the rules back because you can't trust them. Well, Pennsylvania, court trusted Pennsylvania, and Pennsylvania showed that they weren't trustworthy, just like Cuomo wouldn't have been trustworthy had the Supreme Court trusted Cuomo. So now Pennsylvania's got to explain to the court why it didn't keep its promise to the court and why it violated Justice Alito's direct order. Pennsylvania's blown out of the water. Bye, Pennsylvania. Now, with regard to the complaint in general, actually, let me get to the brief first, because there's something beautiful in this brief. For those that know how to read legal briefs, you're going to love this. I strongly recommend you take the time to read through this. It's fantastic. So a brief will start with a statement of the case. This is what the case is about. Lawful elections are at the heart of our freedoms. No right is more precious in a free country than that of having a voice in the election of those who make the laws under which, as good citizens, we must live. Other rights, even the most basic, are illusory if the right to vote is undermined. And that's quoting Westbury v. Sanders, 1964 case. Trust in the integrity of that process is the glue that binds our citizenry and the states in this union. And then it goes on. Additionally, but I want to get down to page 19, because leave it to Texas to cite Whataburger. Whataburger of Virginia, Inc. versus Whataburger, Inc. Wait, Timbo, that was a trademark dispute. Why is the state of Texas citing a trademark dispute in an election law case? I'll tell you why. It gets back to latches and ripeness. Before the election, plaintiff states had no ripe claim against a defendant state. Quote, one cannot be guilty of latches until his right ripens into one entitled to protection, for only then can his torpor be deemed inexcusable. Torpor, for those that don't know, is sleepiness, falling asleep on the job. Only then can its delay be deemed inexcusable. So if you delay after the case is ripe, then doctrine of latches is going to bar your suit. But you can't invoke the doctrine of latches before the case is ripe, as I've already explained. But leave it to Texas to file, to use in support of that proposition, because I'll tell you, there's a lot of other laws a lot of other cases they could have cited in support of that proposition. But no, they cited Whataburger. Why is Whataburger so great? Because Whataburger is open even in hurricanes. That's right. The last hurricane in Texas, Whataburger drive-through was open. So read the brief. The brief lays out all the arguments in detail, goes through each state, how each state violated the laws. And for time, I'm not going to do that. I'm going to trust you can read it on yourself if you're interested. And if you're not interested, I'm not going to waste your time by going through state by state. We're all familiar with the violations of state law. For example, they cited our great patriot in Detroit, the Indian immigrant, Jessie Jacob. They cited her testimony. They cited the testimony of the UPS driver, or USPS, United States Postal Service driver up in Wisconsin. A lot of the testimony that we've already heard over the last 2 weeks has been cited in this case. So this is all current information, and it lays out for each state how each state violated the law, both the law and the Constitution, and how there seemed to be a common pattern. How did all of these states just happen to stop counting at around 10:30 at night, 10:30 at night? How did all of these states just happen to have massive ballot dumps after counting had stopped? How come in all of those states, the massive ballot dumps went almost exclusively for Joe Biden? So they've shown a common, they've broken each state out individually, and then they've shown the commonality to show why all 4 states, the defendant states, should be brought in this one lawsuit instead of going at them individually. So in the prayer for relief, so what you have in a complaint is you've got a statement of the case, and then you have the list of the jurisdiction and venue. So you have the nature of the action, so they can read, it's like the executive summary, this is what this case is about. Then you've got the jurisdiction and venue analysis, which I told you, this court has jurisdiction for these reasons. And here the reason is because it's a controversy between 2 or more states. It's Texas versus the Commonwealth of Pennsylvania and the states of Georgia, Michigan, and Wisconsin. So federal question, you've got jurisdiction. And venue, Supreme Court is the court of first impression for such cases. There's no other court competent to hear this. You're the only court in the country that can hear this. And then the parties, who the parties are, and why the plaintiff has standing. And then it goes into the legal background, and then into the and the legal background is under the Supremacy Clause of the Constitution, laws of the United States made pursuant of. Constitution shall be the supreme law of the land. That's the Supremacy Clause in the Constitution, Article 6, Clause 2. Individual citizen has no federal constitutional right to vote for electors for the President of the United States unless and until the state legislature chooses a statewide election as the means to implement its power to appoint members of the Electoral College. That's Bush 2, which I talked about earlier. There's no right until a state creates an election. State legislatures have plenary power to set the process for appointing presidential elections, and if that schema, that electoral schema, is not followed, it's a violation, and the legislature has the plenary power, and it is entitled to take it back, to claw back the right to appoint the electors. So it's the legislature saying, okay, Secretary of State, you can run an election, but here are the rules. And if the Secretary of State violates the rules, the legislature can then say, well, you violated our rules, therefore we're exercising our plenary power to appoint the electors. We're taking back the power from you, and we're going to do it ourselves. And then it goes into that at the time of the founding, most states did not appoint electors through popular statewide elections. In the first presidential election, 6 of the 10 states that appointed electors did so by direct legislative appointment. And that's the McPherson 1892 case. Now, remember, what I said, it said 6 of 10 did not. Only 10 states submitted electors. We had, I think in 1789 or 1788, there were, I think there were 15 states then. So I think 5 states didn't submit electors. Only 10 did, and 6 of the 10, the legislators did. In the second presidential election, 9 of the 15 states that appointed electors did so by direct legislative appointment. In the third presidential election, 9 of 16 states that appointed electors did so by direct legislative appointment. This practice persisted in lesser degrees through the election of 1860. 1860, Lincoln's first election, was the first election in the country. 1860. Okay, so this is 112 years after we started having elections. It was the first election where every state selected its electors based on a popular vote. Before 1860, one or more states were state legislators were directly appointing their electors. So the defendant states are barred from saying that it's not within the legislative power to appoint direct electors. It's like, no, it is, and it's been done quite often in our history. Though history has now favored the voter, citing Bush 2, there is no doubt of the right of the legislature to resume the power of appointing presidential electors at any time, for it can neither be taken away, abrogated, nor abdicated. And that's, again, citing McPherson, 1892. Given the state legislature's constitutional primacy in selecting presidential electors, the ability to set rules governing the casting of ballots and counting of votes cannot be usurped by other branches of state government. Meaning, if the Secretary of State doesn't do what the legislature demanded, that's a violation. And courts can't change the requirements either. Only the legislature can change the requirements. And if the requirements aren't met, it's an invalid election. The framers of the Constitution decided to select the president, and this is one of my favorite quotes. It's our beloved James Madison in Federalist 68. The framers of the Constitution decided to select the president through the Electoral College, quote, to afford as little opportunity as possible to tumult and disorder, and to place every practicable obstacle to cabal, intrigue, and corruption, including foreign powers that might try to insinuate themselves into our elections. Were our founders brilliant? They didn't know about voting machines. They didn't know about internet. They didn't know about Dominion this and Smartmatic that, but they did know human nature. They didn't even know about the Democrat Party, because the Democrat Party, although it has no official birth date, wasn't around. Andrew Jackson was the first Democrat elected. So they didn't even know about the Democrat Party. They certainly didn't know about the Republican Party, but they did know human nature. They knew that with the prize as powerful as the presidency, that there was going to be chicanery. There was going to be shenanigans. There was going to be fraud, deceit, and deception. They knew human nature, and they guarded against it by giving us the Electoral College, which is why there's going to be an even greater call now on the left to abolish the Electoral College through the National Popular Vote Compact. It is absolutely imperative to the survival of our republic that we retain the Electoral College. Significant damage was done to the constitutional schema with the passage of 17A by allowing direct election or popular election of senators. We should not be voting for our US senators. Our state legislators should be selecting our senators just the way they did before 17A was ratified. That was one of the progressives. That was probably, that and 16A and the creation of the Fed were the three big progressive wins back in the teens, back 110 years ago. We absolutely have to retain the Electoral College, and James Madison tells us why. Because they wanted to afford as little opportunity as possible to tumult and disorder, and to place every practicable obstacle to cabal, intrigue, and corruption, including foreign powers that might try to insinuate themselves into our elections. So then it goes on into the facts, and I won't repeat the facts because you all know the facts. And then it goes, the complaint, after the facts are recited, it has what are called counts. And a count is the meat. These are the core allegations that are being made in the lawsuit. So count one is the electors clause. The Electors Clause of Article 2, Section 1, Clause 2 of the Constitution makes clear that only the legislatures of the states are permitted to determine the rules for appointing presidential election. The pertinent rules here are the state election statutes, specifically those relevant to the presidential election. Non-legislative actors lack authority to amend or nullify election statutes. Under Heckler v. Cheney, 1985 case, conscious and express executive policies, even if unwritten, to nullify statutes or to abdicate statutory responsibilities are reviewable to the same extent as if the policies had been written or adopted. So that means the Secretary of State simply telling the county boards of election don't require signatures. That is an executive policy that can nullify the statute or to abdicate statutory responsibilities, and it's reviewable to the same extent as if that had been a written requirement. Count 2, let's see. And then it says the actions set out in paragraphs 41 to 128, that's the recitation of facts, constitute non-legislative changes to state election law by executive branch state election officials or by judicial officials in defendant states, Georgia, Michigan, Wisconsin, and the Commonwealth of Pennsylvania, in violation of the Electors Clause. So it's saying even if a policy isn't written down, it's reviewable. These 4 states did things, as we said up above in our statement of facts, that violated the state law, so you review it. And therefore, electors appointed to elect the Electoral College in violation of the Electors Clause cannot cast constitutionally valid votes for the office of president. So count 1 is the Electors Clause. The states violated the Electors Clause, and they therefore should not be allowed to cast constitutionally valid votes for the office of the president. Count 2 is the Equal Protection Clause. And this is where we get into the Equal Protection Clause prohibits the use of differential standards in the treatment and tabulation of ballots within a state. And that's Bush 2. And then it's saying that the one person, one vote principle requires counting valid votes and not counting invalid votes, citing both the Reynolds case and the Bush 2 case. Quote, the votes eligible for inclusion in the certification are the votes meeting the properly established legal requirements, meaning only legal votes can be counted. And then it says that the actions set out in the above paragraphs with regard to each state, paragraph 66, 73 for Georgia, et cetera, created differential voting standards in defendant states, Pennsylvania, Georgia, Michigan, and Wisconsin in violation of the Equal Protection Clause. Also, the actions set out in paragraphs violated the one person, one vote principle in defendant states, Pennsylvania, Georgia, Michigan, Wisconsin. And then the kicker, by the shared enterprise of the entire nation electing the president and vice president, equal protection violations in one state can and do adversely affect and diminish the weight of votes cast in states that lawfully abide by the election structure as set forth in the Constitution. And that's what I was saying. Texas has standing here to sue, and they've got a legitimate beef because Georgia, Pennsylvania, Michigan, and Wisconsin didn't follow the rules. They didn't follow the Constitution, and we did. And by them not following the Constitution, it hurts us Texans who did follow the Constitution. And then count 3 is due process clause of the 14th Amendment. And it goes into an analysis of due process law. And then in the prayer for relief, and this is what you're asking the court to do. So the states are requesting the court issue the following relief. A, declare that defendant states, Pennsylvania, Georgia, Michigan, and Wisconsin administered the 2020 presidential election in violation of the Electors Clause and the 14th Amendment, the Equal Protection Clause of the United States Constitution. So declare that they violated the Constitution. B, declare that any electoral college votes cast by such presidential elections appointed in the defendant states are in violation of the Electors Clause in the 14th Amendment. So declare that the election violated it, or declare that the the administration of the election violated the clause, declare that any electors that might be appointed violate the electors clause and equal protection clause. C, enjoin defendant states, meaning issue an injunction prohibiting them from using the 2020 election results for the office of president to appoint presidential electors, meaning they can appoint electors, they just can't use the election results to appoint the electors. D, to enjoin the defendant state's use of the 2020 election results for the office of president to appoint presidential electors to the Electoral College and authorize, pursuant to the court's remedial authority, the defendant states to conduct a special election to appoint presidential electors. So tell the states they can't appoint electors and order them to hold a special election. So that's alternate relief, right? You can do this. You can hold the election invalid. You can tell them not to appoint electors. You can prohibit them from appointing electors, but you can order them to have a special election. E, if any defendant states have already appointed presidential electors to the Electoral College using the 2020 election results, direct such state legislatures to appoint a new set of presidential electors in a manner that does not violate the Electors Clause and the 14th Amendment, or to appoint no electors at all. So in Pennsylvania, you've already certified your results and you've already appointed your electors. Well, guess what? You can't use those electors. You can have a new set of electors that don't violate the Electors Clause in the 14th Amendment, or you can just not appoint any electors at all, which had been done previously as stated above. Prayer F is to enjoin the defendant states from certifying presidential electors or otherwise meeting for purposes of the Electoral College, and then award costs to plaintiff state and grant such other relief as the court deems just and proper. So that's the complaint. I think that this is by far the strongest case that has been brought so far. It ties all of the states together. A decision in this case, just like the decision in Bush v. Gore 2, which was limited to one state, because this entails 4 different states, which collectively have electoral college votes sufficient to change the outcome of the election. I think the court will have no option but to grant the motion for leave to file the complaint. I think that they will accept the case. They'll grant certiorari. I think that the next step will be to set a deadline for briefs to be submitted to the court and a date for oral argument. And I do believe that Attorney General Ken Paxton won't be arguing the case. I don't know that the Solicitor General of Texas will be arguing the case. I think that they will step aside for Senator Cruz. It's time for the cruise missile. So I'm really excited. Brooke is really excited. You should be really excited. This is what we've been waiting for. This is the big one. This is, you know, we kept saying, don't stress, don't stress, don't stress. Come in off the ledge. Don't jump off the ledge just because we lost a Pennsylvania state trial court case. Don't jump off the ledge just because we lost a Pennsylvania state appeals court case. Nothing matters except SCOTUS. And none of those other cases might be folded into this case by the court, but the court might very well just go ahead and decide this case on its merits and keep it clean. All right, that's all I've got for you now. Until next time, God bless you. God bless these United States. Keep fighting the good fight.